clients will often say to me, I'm ready to settle. Let's try to move this case along. And sometimes it's appropriate to do so and sometimes it's not. Let me address that. I explain to clients when they're hurt, we can't generally move forward with confidence until we know what they've suffered, until we know they're over it, until we know they've reached their plateau of essentially where they were before the accident. And I try to explain it as follows. I say to folks, we can't go to court until your fire is put out and we know it's out. What does that mean? And here's my example. Suppose that you own a hotel and there are 100 rooms in the hotel, and that some mentally unstable person sets a fire to your hotel and the fire is burning. You come to me and you say, Mike, I want to sue this person. I want to rebuild the hotel. And I would say, fine. And we might determine that it would take $10,000 to rebuild each room. Well, you see, we can't go to court until the fire is out and we're able to survey all the rooms to make sure we've got the correct count of the number of rooms they have to rebuild. And you can't do that until the fire is out. If you rush to court before the fire is out, the lawyer might mistakenly figure, well, we've got to sue for 10 rooms. I only see that 10 rooms are destroyed. And the lawyer could go to court and get 10 times 10,000, which would be 100,000. But that wouldn't be enough, because by the time the lawyer gets back to the hotel and the fire's out, you might discover that there are 20 or 30 rooms that have been destroyed. And you didn't sue for enough money to make the client whole and to reach a fair result. And so for that reason, in my expression, generally we don't want to go to court until we know the fire is out and we know what your damages are. Otherwise, that we present a risk that you wouldn't be fully and fairly compensated, and we certainly don't want we want to avoid that.